Judge, I object. I move to strike all of this witness's testimony. You want to know what this is about? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney, and let's say this is a medical malpractice trial. The defense has put on a witness to bolster their claim that their doctor did absolutely nothing wrong. And now, during the course of his questions and the answers that the doctor is giving, there's something that I feel is inappropriate. So I jump up out of my seat. I say, Judge, object. I object to this question. I object to this answer. I object to this witness testifying. And now I have to give the judge a legal reason why. If the judge agrees with me after this witness has done all this testifying, there is a possibility that the judge will agree and say, ladies and gentlemen, you are to disregard all of this witness's testimony. We are going to strike this witness's testimony from the record. Now, what does that mean? Does that mean that the court reporter actually tears up all the questions that were asked and all the answers that were given? No, that's not what happened. What it does mean is that the jury is not to consider this witness's testimony when they go to deliberate and decide whether we are more likely right than wrong. Now, you might be thinking, how can you immediately forget what you just heard this witness say? The reality is that you can't. It's like you hear a bell ring, right? And now somebody next to you says, hey, I want you to forget that the bell just rang. Well, you can't unring the bell, just like you can't unhear what you just heard. So the judge gives the jury a curative instruction that basically says, listen, there's a legal problem with what this witness has said. And now because of that, his testimony is not to be used when you consider whether the injured patient is more likely right than wrong. That's what the judge means when he says you are not to consider this testimony. Now, even if the judge doesn't agree with me, at the very end of the trial, when the judge gives the jury legal instructions, one of the instructions he's going to tell the jury about is that if you find that a witness has lied about one little thing, you, the jury, have the right to disregard all of this witness's testimony. That's known legally as falsus in uno. So if this happens to be a contradiction, where we caught this doctor in a lie, now I'm going to highlight that fact to the jury at the end of the trial. And if the jury agrees with me that this doctor has lied about one particular issue, they have the right to disregard all of this witness's testimony. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in these medical malpractice cases here in New York. You know, I understand you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit but haven't done so yet because you still have questions that need answers, what I invite you to do is pick up the phone and call me. I can answer your questions. You know, this is something I do every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.